A wife is called to testify against her husband who is facing trial for a criminal offense. In this kind of scenario, we love take a back seat for justice. I am Ada the Law, and I am passionate about making legal knowledge accessible to everyone. So if you follow my page, you will not regret it. First of all, for you to testify in court as a witness, you must be competent and compellable. Those plenty grammars, let's break them down. When they say a witness is competent, it means the witness can go to court and give evidence. If you can understand questions they ask you and answer them correctly, then you're a competent witness. While a compellable witness is a witness that is competent and has that legal duty and obligation to testify in court. Example, someone committed a crime in your compound and you were around and witnessed the crime that happened. You owe that legal duty to testify in court about what happened in your compound. So if the court sends necessary invitations to you and you refuse to honor the invitation, then you're committing an offense called contempt of court. Every person is competent unless the court considers you to be too young, too tender, or too old, or you have a disease of the mind or disease of the body. That is left for the court to decide. Competent witnesses may not be compellable, but every compellable witness is competent. Yes, because the court cannot compel an incompetent person. This simply means that you may know what you're doing, like you can understand questions and actually respond to them correctly, but there are instances where the court cannot compel you to give testimony in court. For example, a lawyer cannot testify against his client, whether they are still working together or not, unless the acts of his clients were illegal. A judge cannot testify against a person based on what he heard while he was judging that person's matter. Public officers like the president, the vice, and even the governors cannot be compelled to come to court to give testimony. This is because they have the immunity not to appear in court while they are still on seats, and so on and so forth. These persons are competent witnesses, but they are not compellable. Now, this is the main deal. Generally, spouses cannot testify against each other in court, but there are exceptions. According to the Evidence Act 2011, Section 182, a spouse of a monogamous Christian marriage cannot be a competent witness to testify against his partner or her partner that is facing trial in court, except the partner that is facing trial has given his consent that his other spouse should come and testify against him. A spouse can testify against their partner whether their partner was charged for sexual offenses under the criminal code, like rape, indecent sexual practices between males, gay, defiling underage girls, and so on and so forth. Or where the partner facing trial was actually charged for committing offenses against the property of the other spouse, in the manner that if they were not married, the partner facing trial could have been charged for stealing. Or where a partner, whether wife or husband, is facing trial for inflicting violence on the other partner. For example, domestic violence. The partner that was injured or beaten can testify against their partner that is facing trial. Now you know what the law says about couples testifying against each other. What are your thoughts? Drop them in the comment section. Is there any aspect of this topic you want me to break down for you? Drop them in the comment section. Please don't forget to like, comment, and share to educate others. Thank you.